Alex here with part 98 of the My Docket series on child custody and visitation. As with my previous videos, I will take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains a detailed disclaimer and the underlying purpose of the series. Two things that I glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. For those of you who wonder why I always go over those two snippets, the answer is because if I don't do that, probably 3 out of 4 emails that I get on the My Docket series have nothing to do with the videos. It's number one, somebody who's worried my videos will be used against me in court, which is impossible at this point. And number two, it's people that are upset. They think I'm using the videos to somehow impact my court case, which is impossible because my court case is over. Or there's sometimes people who think that the videos are me being upset because I lost, but I didn't lose. My case is over. And I definitely don't think a TPR is a loss. So anyway, into the video, we have opposition to motion to quash. This is my opposition to my ex's attorney's motion to try to quash my subpoenas. And by the way, the video following this is my reply to my ex's opposition, resisting my motion to have her turn over the mental health providers, the identities of those mental health providers. Basically, this video and the next video are going to be my, I guess you could say, response to this idea that these documents are somehow privileged, which it's funny because my ex's attorney isn't even using that word. She's saying confidential, which technically is true, but that's not what controls whether or not they are to be, turned over to me or not. So, it's like that. It's sort of the lying by not omission. It's a form of lying where you use a phrase or you put together your proposal in a way that makes it seem like you're asking for one thing, but if anyone calls you out on it, you can be like, well, no, I didn't really say that. I know it seemed like I did, and I know I kind of worded it that way on purpose to make it seem like I did, but if you go back and you look at the exact words put together on that piece of paper, you'll see that I just used the word confidential. So I didn't exactly lie, and it's kind of just the attorney's version of what my ex often does, only instead of in the facts and day-to-day circumstances of our case, it's with the law. So I guess at this point we can go ahead and go into what I have filed. And here we have my opposition to quash. No, I don't know why she called it that either. So she filed like a motion to quash my motion to compel. It would have just been an opposition. When you don't want a motion to be granted, you file an opposition. I don't know why she's wording it that way. It's strange. First standard introductory paragraph is I am introducing myself. I'm indicating to the court that I am appearing in proper person without an attorney, and that I am filing an opposition to my ex's motion. Looks like I don't. This opposition is based upon the memorandum of courts of authorities on file herein, specifically the motion filed on October 11, 2012. Okay, yeah, I should have indicated the date that this opposition was filed. Apparently I didn't do that. It's a good idea to do that, guys. Scrolling down into the memorandum of points and authorities, ex parte filing is inappropriate. Maybe she did label it ex parte, but I just feel like I can't remember her filing a request for submission. Maybe she did. In any event, it doesn't matter because the court hasn't made a ruling on it yet anyway. So I am getting my due process anyway. Here it is. I'm filing my formal written response. Anyway, let's take a look here. So my ex served, oh, she did. She filed a request for submission on the day she filed a motion. So weird. And if you guys want to know why it's weird, there's rules local rules, and there's also precedent as to when you're allowed to file ex parte papers. You can't just do it whenever you want to. And in fact, if you want to learn more about what I think and why they usually fail, you could just take a look at my video Ex Parte Perils, because I talk about some of the due process concerns, some of the constitutional concerns that come up when you deal with ex parte files. Next we have, or ex parte filings, next we have authority and logical basis behind reviewing certain procedural applications ex parte. Other than these exceptions, the Supreme Court of Nevada has discussed, and this is the case, guys, Anastasatos versus Anastasatos. This is a case where they explain that Nevada is a notice pleading jurisdiction and that parties need to be given reasonable advance notice of an issue and an opportunity to respond to those issues. It's pretty standard due process constitutional stuff there. If somebody's trying to take something from you, you need to have an opportunity to explain to the court why they shouldn't be allowed to do that, whether it's your freedom, whether it's your children, whether it's your money, whether it's your property. You know, the list goes on. Next is generally ex parte orders require notice being served upon counsel. So if you're looking for, temporary restraining orders, with rare exceptions, when notice of an ex parte motion would defeat the purpose of the motion itself, it can be obtained without service. And that's true. Here's a local rule that I cited, WTFCR 43 subsection B. My ex doesn't even imply that our child is in immediate danger, nor does it discuss any disposition of property. And these are the two requirements under the rule. Again, guys, I feel like this is a moot issue because I got my response in. So, I guess I could have argued I would have taken more time to do better research. That's possible. Respondent mischaracterizes my motion to compel. I'm not attempting to gain backdoor discovery. This is something that I talked about. Through some diabolical scheme. I cited Rule 16.21 in my original motion, so the court will be aware of it. Okay, so I guess what here I think she's trying to do is she's trying to say that I didn't follow Rule 16.21, like if I'm trying to be sneaky. But I'm pointing out to the court, if I was trying to be sneaky about Rule 16.21, why would I bring it up in my motion? It's brought up in my motion to tell the court, hey, there's this rule that I'm trying to satisfy. So that's just another inane, I guess you could say, assertion that I'm having to deal with. My ex's application of 16.21 makes little logical sense. The purpose behind the rule prevents me from sending my ex interrogatories, requests for admissions, etc. I talked about these in a previous video. I'm suggesting that the court construe my ex's motion as a motion to strike. And by the way, guys, okay, so I have more experience now, and I've read some precedent from the Supreme Court that indicates that they don't like people filing motions to strike motions. And I know that it has to do with there's two things that I think. First of all, how do you deal with it in the sense of a timeline? You're trying to strike a motion with the motion, but the time to respond to that motion is going to lapse before the time to respond to your motion to strike is going to lapse. So you've got this problem straight away with the timelines, or the computation of time, or the time limits. That may be a better phrase to use there. But then the second issue is, if you don't like what somebody's saying in a motion, why not just file an opposition? And I guess there's some arguments behind why attorneys might want to do this, and maybe other states and other jurisdictions deal with it differently, but I have read precedent in Nevada indicating that the Supreme Court of Nevada does not like people filing motions to strike motions. So maybe what I should have said here is that the court construe my ex's ex parte motion as an opposition. Just an opposition to my motion to compel. Or that would probably be what would have been better to say. My ex, let's see here. Alternatively, I suggest the court construe her motion as an opposition. There we go. Okay, good. That's what I said anyway. Next paragraph is, the court did view my ex's psychological records in camera 4 years ago. Yeah, he's not going to remember that. But parties and the court were looking at the information in a different light. On my ex's own admission, the court determined that she was not a danger to anyone but herself. Now, however, the issue is not how her conditions might be explicative as to her conduct regarding our son's education, which is true. I'm trying to say that these mental health records are now relevant in a different way. My ex is having serious issues getting our child to school, keeping our child consistent, or keeping our child in compliance with school rules. And I'm trying to say that these records might shine some light on why she's having that problem. Okay, then we have, if granted, a hearing is mandatory. Pursuant to Local Rule 43, subsection 3b, all ex parte orders require a hearing within 10 days. That's only if it's granted ex parte. If he grants this on having read my opposition, then he doesn't have to do that. Conclusion, it would be inequitable to give my ex's motion consideration without allowing time to do research on case law or statutory law. I'm not an attorney. I've not memorized every relevant piece of authority. Okay. Parties should be ordered to provide each other written notice. Okay, so there's one thing I don't like about this. I have a beef with the ex parte nature of her approach, but I still should have addressed the substance of what she was asking for as well. I feel like it would have been prudent for me to put something in here about why I was entitled to know the identities of those providers. So that would be something that in hindsight I would have done. And it would just be citing two things that I can think of. Number one, the best interest factor, which has to do with the mental health of my ex. And number two, relevance. There's a couple of statutes and cases that discuss relevance, and basically the Supreme Court has stated that relevant evidence is generally admissible. Unless there's some exception that applies, it's admissible. So anyway, these things I think I should have put in this, is this a reply? This is an opposition to motion in this opposition, and the fact that they're not there is disappointing, but of course, this is way back when. I didn't know everything then that I know now, and I just wanted to deal with that one problem that I had. Scrolling down, we've got the declaration, which is going to swear under penalty of perjury that the facts alleged in this opposition are true and correct. We have my Rule 5 certificate of service, which is indicating to the court that I served this upon my ex personally, which means I took it down to our law office and handed a physical stack of these papers to the lady behind the desk. And we have here, actually, she had two employees. One was a guy, one was a lady. We have here the motion opposition notice, pretty standard document, and the check marks on here indicate that I don't have to pay a filing fee. Going into the next document, we have a certificate of service by my ex's attorney. So this document probably would have made more sense to include 2 videos back when she filed her motion, her ex parte motion to quash my motion to compel. Gosh, that is such a weird approach. Anyway, this would have probably made more sense to include in that video, but I just now got to it and I just now noticed it. So just so you guys know, this is a certificate of service not filed by me, filed by my ex's attorney, and it's not filed on the document we just went over. It's filed on the document that she filed a couple of videos back. If you look at the last 2 or 3 videos, you'll notice that the dates on all of those filings are the same day. So it looks like these just got shuffled out of order a little bit, but no big deal. It's just a certificate of service indicating that my ex's attorney mailed this document to me under, wait, did she? Yeah, mailed this document to me under Rule 5. And moving on. Going into the aftermath, I filed one document. It was a free filing, so I incurred $0 in costs. My ex's attorney filed a document as well. It also was a free filing, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney would have, to file that certificate of service, 5 minutes max. And to review my opposition to motion, I feel like 10 minutes max. It just was not a very long paper. All it did was deal with some procedural gripes that I had on her filing an ex parte, on her filing a motion to quash another motion, all the weirdness behind it. I really didn't even deal with the substance of what she was asking for, so I think 10 minutes is pretty reasonable. I doubt she even bothered to talk to my ex about it at all. A total of 15 minutes at the rate of $250 an hour is going to come to $62.50 for my ex. And as with my previous videos, feel free to leave any questions you have down in the comments below, and I will see you guys next time.